Um, the third issue in front of the Supreme Court could nix everything, period, end of comment. And it goes like this. When I was in law school, I learned that courts try very hard not to make decisions that they don't have to make. In other words, if there's a way, a procedural way, for example, that a court does not have to, would provide a court a method for not making a decision, as we say, on the merits, they may go with that procedural manner. If they tend to go to the merits of it, then they are oftentimes called an activist court. There is a law called the Anti-Injunction Act, and this is briefed for the Supreme Court. The Anti-Injunction Act is an act that says if you and I, say today Congress passed a law saying Dave and Bruce are going to pay an extra 10% of tax next year, we could not go to court and seek an injunction stopping that. We would have to wait to be taxed, appeal to the IRS, and then take it up through the chain. Okay? So in other words, you can't, and this brings us down to whether or not this is a tax. If the Supreme Court decides that the Anti-Injunction Act applies, the tax in this situation for the individual mandate does not start till 2014. So you would that could make the whole thing go away. In which case, I think politically, it would just go away, it would go into effect, and I don't think you'd have many more challenges to it. You might in 2014, of course, 2016 will be the next election, so you never can tell what happens. But that's what we're talking about. We're talking about the issue of, do these people complaining about Obamacare, do they have standing to be there complaining? And that's a real grounded, basic concept of the law. Do I have standing to be in court?